Matter of Jeter v. Poole. Counsel?
Appellant asks to reserve 5 minutes for rebuttal.
Yes.
Thank you. May it please the court, my name is Carolyn Kubitschek, and I represent Shani Jeter, who seeks to clear her name in the State Central Register of Child Abuse and Maltreatment after having prevailed in the family court on identical charges of child neglect. Had Ms. Jeter waited until 2022, or even today, to request a name-clearing hearing, Social Services Law 422 requires that her name be cleared because the family court order is binding at that administrative hearing. However, because she acted expeditiously, respondents have fought all the way to this court, arguing against giving her relief. Chapter 56, Part R of the laws of 2020.
Could she try again? Sorry, straight ahead of you. Could she try again?
Yes, sorry, Your Honor.
Could she try again? Could she file now and ask for another name-clearing hearing?
I'm sorry, could she try again? No, she could not try again because you only get one chance at a name-clearing hearing.
So do you get another chance if somebody makes a request and the register provides information? Does that give you a second chance or no?
No, you get the second chance at a hearing only if you never had a hearing the first time around. And there are many people who do not exercise their right to have an immediate name-clearing hearing, and they do wait until they're searching for a job, and then they have the hearing that they didn't have before. But she can only have one hearing total.
Even to argue that there's been a change in the law that affects the outcome? As opposed to just someone who says, well, I want a second bite at the apple. Nothing else has changed.
The state would not give her a second hearing if she asked for one, even though she said there's been a change in the law, I want another chance.
Have the sealing rules changed also recently?
The rules, it's the same statute, chapter.
But have the rules governing the sealing of those records, depending on outcomes, have those changed?
The rule governing sealing now says if the person prevailed in the family court, that that family court order is effectively res judicata, so that there will be no hearing. But her name will be cleared.
And if they did not prevail?
If they lost in the family court, the rule has always been,
and
since the statute was enacted back in the 1970s, that they lose. They will not get their name cleared.
And it's not sealed at all for any purpose?
It will be sealed after 8 years.
And is that
or if it was child abuse rather than child neglect, it will be sealed after 28 years.
Has that always been the rule in those latter two conditions?
No, the law changed so now that the sealing will occur after 8 years for people whose names are on the register and who have not cleared their names.
And would that apply to your client? Would that apply to your client, the sealing rules, the new sealing rules?
Yes, her name will be sealed in 2027, 3 years from now.
To go back to your opening statement, you said that she acted expeditiously with respect to requesting application of the amendments. I take it by that you mean she asked as close in time to when the amendments went into effect. Is that correct?
I'm sorry, I didn't mean that at all.
What did you mean?
She asked as soon as she learned that her name was on the State Central Register as a confirmed child maltreater, she asked that it be taken off.
And when was that?
That was in 2019.
But when specifically did you make the argument that the statute, upon its effective date, applied to your client?
In the appellate division,
Right. And
which
was that
the court of first instance.
And in your view, was that the first juncture at which that argument could have been made? And
Yes,
if so, why?
Because the argument could not have been made before because the law was not in effect before.
But couldn't she have argued before with respect to the effect of the ACD even at the proceeding?
If she had had a lawyer, which is my second point, the lawyer could have, and undoubtedly would have made sure that the court, that the administrative law judge understood that the charges against Ms. Jeter had been dismissed after an adjournment in contemplation of dismissal. Ms. Jeter, who is pro se and has no legal training at all, had no idea that this might be an important factor in her
If you
case.
were to prevail on your argument about when the statute applies, would your client have all the relief that she's seeking?
Yes. Yes, her name would be cleared, and she would have all the relief that she is seeking.
Counsel, let's say that we agree with you on, I'm trying to figure out the effect, one of these two bases. Either the statute should have been applied at that time, or that she had a right, a constitutional right to counsel, right? You're arguing that.
Yes, Your Honor.
And you're also arguing that you don't have to raise that at the hearing if you're unrepresented, I take it, that there's no preservation issue here.
We are arguing that there is not a preservation issue here because with regard to the statute itself, there was nothing that Ms. Jeter could have raised at her hearing.
Well, she could have said I have a right to counsel, right?
Oh, on the right to counsel, yes. On the statute that was not yet in
So
effect.
let's say we go with right to counsel in this administrative proceeding, and you didn't have to raise it because there's not a preservation issue, so what effect would that have on all the hearings that have taken place so far where there was an unrepresented party?
Well, Your Honor, because of the doctrine of administrative finality, it would only, the rule that we're seeking, the right to counsel, will only apply to people who have cases that are still alive somewhere in the administrative pipeline or on appeal to the court system. People who who lost their hearings and didn't file an Article 78 or filed an Article 78, lost and did not appeal, their cases are over.
So it would only apply, in your view, to that limited universe of cases that are somewhere in the pipeline of being actively litigated?
That's correct, plus people who come in the future.
What would have happened, or what's your experience if she had asked for an attorney? What would have happened?
They would have told her no. They did tell her no, and that's one reason why
Where exactly did she request, and are you referring to the letter?
she got a letter saying, "We will not give you a lawyer." That's a pretty strong indication to a pro se litigant, don't ask for one. And if she had asked for one, it would have been futile for her to ask because they were going to say, no, you don't get a lawyer, as they're saying, as I said, in the appellate division, and as they say now, no lawyer. This court has held that you do not have to exhaust administrative remedies if to do so would be futile. Secondly, because it was a constitutional issue, the request was based on a constitutional right to counsel. She did not waive it by not raising it.
How large is this universe of people who would be affected? Let's say we agreed with you by this rule. I mean, the husband was able to get a lawyer
There were
free.
614 people who had pro se hearings in 2021. That number probably will go down because the law changed. The same 2020 law said that a person will not be put on the state central register in the first place unless there is a preponderance of the evidence that she abused or neglected her child. Up until 2020, the law was a person's name would be put on the state central register if there was only some credible evidence. And we're seeing the effects of that already because in 2020, before the law was in effect, approximately one-third of the people who were reported to the state central register were marked, substantiated, confirmed, and had their names on and had a right to get off. Now that the new law is in effect, only 1/5, 20% of the people who are reported to the state
it
central register
clear-
even get on. I'm
Is
sorry.
it clear that it is because of counsel, or is that a change because the burden is now changed, and it's the same in both instances. So doesn't that take care of the problem?
No, Your Honor, because people are still being put on the state central register wrongfully. About half of them are winning their hearings. So that's a substantial
So are
number
they
of people
winning
getting
with-
their names cleared.
Are they winning with lawyers or because the standard's been changed?
Well, the standard has been the same for getting your name off. The standard has been preponderance of the evidence since 1996
To
when
get
this
it off.
court, to get off, when this court decided Lee T.T.
But in the first instance,
But fewer people are getting on. And that is an important, change for
Counsel,
individuals.
With respect to your argument about the constitutional right to have state-paid counsel in these kinds of proceedings, you've just gotten a number of questions about how many people go to these proceedings, how many of them have lawyers, how many of them don't have lawyers. There could be questions about how much would it cost to create a assigned counsel program. Do you think that it would be advisable, prudent, to have some sort of notion of what all these factors are before you create an assigned counsel program? Or do you think that's totally irrelevant in the context of the constitutional right you're arguing?
Well, it is a factor that the court said in Lee T.T. The state's interest, including a fiscal interest, is a factor. However, there are a couple of responses, and the first is that the state did not raise that issue in its answer, and they did not raise it in the appellate division. If the cost were truly prohibitive, they would have raised it immediately. The second thing is that this court may not have to decide that at all if it chooses not to, because this is not a class action lawsuit. This is Ms. Jeter. Ms. Jeter is saying that she has a right to counsel.
But how would that be different for anybody else? I mean, I understand your procedural point, but how would that holding not apply to anyone?
Well,
Who can demonstrate
This court could
indigency.
say that Ms. Jeter gets a lawyer because the interest at stake, which is mostly the same for almost everybody, works in her favor. The state's interest is mostly the same, but the risk of erroneous deprivation for her is so clear
So-
that she
so in
has to
that-
have a lawyer, and the court can reserve for another day
But
whether
how would-
everybody gets a
How
lawyer.
would that work? Would that mean that in each case, you would have the agency look in the first instance? I mean, it just seems like that's a very difficult rule to administer, but
This-
maybe I'm missing something.
It would be a complicated rule to administer. It was the rule that the Supreme Court itself laid down in the case of Lassiter against North Carolina.
Well, could you tie the risk that you just mentioned, in essentially the third factor, to the prior standard that doesn't exist any longer?
The prior standard only exists for getting people on, only changed for putting people on that list in the first instance. It did not change for taking people off the list.
Okay, got it.
And so
Got it.
Well, why is her risk so much higher?
I'm sorry?
Why is her risk so much higher? I'm sorry, maybe I've misunderstood you.
Her risk is high because the record shows that in this particular case, the city behaved in an extremely adversarial fashion, as they do, as they can in other name-clearing hearings. They took advantage of the fact that she didn't have a lawyer. They now say, well, one important document that she sought to introduce into evidence was her daughter's written retraction of the charges against Ms. Jeter, which was the only piece of evidence linking Ms. Jeter to the marks on the child's body.
Can I
seem
ask you to go,
difficult. Sorry.
can I ask you to go back quickly to preservation? I tried to figure out, but I wasn't able to, and maybe you know the answer. In cases, for example, Gideon, where there is a right announced in the first instance, or in cases in which we have found a right to counsel, do you know whether that claim was preserved in the first instance in the trial court in those cases or not?
I do not know whether the claim of right to counsel has always been,
I mean, in the
Right.
first case in which it is initially announced. I couldn't determine
well,
that.
because the issue of preservation, the issue of right to counsel, Ms. Jeter did raise that in her Article 78 petition, in her amended petition. So she raised it at the first court.
I understand,
stage.
but in terms of prior cases, I know your red
terms-
light is on, sorry, but
In terms of administrative preservation, because this court has said so often that if a constitutional right is at stake, a person does not have to raise the issue in front of the administrative agency, I don't have
Thank
an
you.
answer for how often people do and how often they don't. Thank you.
Thank you.
May it please the court, Elizabeth Brody for the Commissioner of OCFS. This court lacks jurisdiction to review petitioner's unpreserved claim that the state constitution requires OCFS to appoint paid counsel for all subjects appearing in administrative fair hearings. This claim was not raised before OCFS, where the
But
agency...
why should it have been? It's their policy. The best that they could do is refer her out.
That's true, but as this court explained in Bingham v. New York City Transit Authority, quote, "A new issue, even a pure law issue, may be reached on appeal only if it could not have been avoided by factual showings or legal countersteps below."
But it
How would it
wouldn't
have been avoided? How would it have been avoided? I'm not understanding. This is, I may have misunderstood this record. This is their policy. They are not going to give anyone a free lawyer. They're not going to foot the bill for counsel.
What Bingham says is that it has to do with issues of ripeness, of standing, that is intimately tied to the preservation
But we're
issue.
talking sort of about the futility exception to the preservation requirement. They told her in a letter, don't bother asking for a paid lawyer. We're not going to give you one. So what else was there for her to do?
Respectfully, the letter did not say, don't bother asking.
Okay,
for
you're
a
right.
paid
I'm paraphrasing in a particularly dramatic way, but they said this office will not provide paid counsel for you.
Said this office cannot provide paid counsel for you. You're welcome to bring a lawyer or another representative to the hearing. If you
Well,
can't
even a
afford
stronger
one-
statement, not may, which suggests that there's some discretion, but cannot, as in suggesting we don't have the funds or we're not authorized to do so.
That's good. That's correct, but I would again encourage this court
What is
to-
the counter step that could have been taken had this been raised in the administrative proceeding?
Well, as the head of the Bureau of Special Hearings stated in the affirmation appended to our amended answer, if somebody indicates that they want counsel, a simple statement, I need a lawyer, they're given a list of pro bono counsel in their respective
But
geographic
that's not
area.
getting her one.
It's not, but again, I think what these
Well, I mean,
courts,
would that satisfy Gideon?
the relevant standard here is not Gideon, where the source of the right is the Sixth Amendment to the
Right.
Constitution. It's instead a due process right, where this court and the Supreme Court have said that you're expressly balancing three different interests. It's not a right standing alone that exists without regard to the state's interests, the state's fiscal interests, or the state's administrative burden. But I would just, going back quickly to Bingham and cases like Tularo, this court has said that the preservation requirement, in addition to allowing the courts below to elaborate on the issue, also has to do with
How
not-
does Mancino impact preservation here?
I'm not sure how Menachino impacts preservation. That was the case saying
Wouldn't
that
it suggest that it's not required to be preserved?
I'm not familiar with what that case said about preservation, but I will note that all we're asking that she have done is what the petitioner did in matter of Brown v. Levine, which was another right to counsel case. That petitioner said, in that case, I want an attorney. The ALJ adjourned the proceeding and gave him contact information for local legal services.
But
he was unable.
There's a distinction, it seems to me, between a right to counsel, which requires whatever the adjudicator is, court, agency, whatever it is, to provide that counsel, and something which gives an individual some assistance in seeking themselves to find counsel. So I'm just not sure how, in light of the letter, and what I take it to be your suggestion that the adjournment would have allowed the ALJ to assist, but not to impose any right. Those seem like different things to me, are they not?
They are different, and this is the last time I'll mention these cases, but in Bingham and Tellaro, this court has said that the preservation requirement, in addition to all of its other virtues, one of the virtue is that it avoids bringing cases before this court when they are academic, when there is no actual case or controversy. If she had been able to get a pro bono lawyer, there would have been no need for this court to hear the appeal, and that's what those cases say.
So let me
But
ask you
even if-
this, let me ask you this. Your argument then turns on, they'll provide her with a list, it's on her to go and find one. If she comes back and says, I called every single number, they're either conflicted out or they're completely unavailable, what then happens?
Well, then the issue would be preserved, and she would be allowed to.
No, I'm
resolve-
not talking about preservation. What would happen? She now has followed through on what you say is all that you had to do for her. What then happens?
Well,
She's
then.
going to proceed without a lawyer.
Yes, although we say.
So we've
again in our-
circled back to that right to counsel.
Yes. So even if this court thinks the claim is preserved, the Due Process Clause of the state constitution does not require OCFS to pay for appointed counsel in all SCR fair hearings.
Do you have an idea about the practical question we asked before about how many people this would impact if we disagreed with you?
We stated in our brief that the number of requests for fair hearings that OCFS receives every year is somewhere between 3,900 and 5,200. And so we did some back-of-the-napkin calculations in this brief, primarily to respond to petitioners' arguments that the costs would be small or negligible, and it was in the tens of millions of dollars.
Is
So the
that,
attorney's
is that,
fees-
are those numbers after the new legislation took effect?
No, the petition was.
No, I mean
petition was-
the numbers you gave me.
No, I understand. Her petition was amended in 2021, and we had to answer, I think, in early 2022. The amendments took effect January 1st, 2022. So at the time we answered, there was no
Right,
data
and do you
on
have
this.
data for 2023, for example?
Which is, we don't, which is why respectfully we would say that this is a question for the legislature in the first instance, and that's precisely the kinds of figures, costs, things that can be studied by the legislature.
Would you address the question of the applicability of the statute? And specifically, I'm interested in why you think it's retroactive as opposed to a changed law, which would apply at the time of its effective date.
Because the way that the law works mechanically is that it amended the administrative review procedures that OCFS applies in fair hearings. This is subdivision 8 of the law, and that's where the changes take effect. There are also,
But as it comes before the appellate division, right, why is it your view that at that point in time, application of the new law is retroactive and reaching back, as opposed to applying it as it sits before the appellate division as a changed law?
two responses to that. I think on a basic level, it's retroactive because the hearing and the proceedings concluded a long time ago, and it would require reopening that procedural step, thereby making it retroactive. But on another level,
It would-
I'm sorry, I don't understand that.
Yeah, me either.
it would require
Why
reopening.
would you need
of
to
proce-
reopen the proceeding? Why isn't the relief sought just a removal of the name from the register?
Yes, but the way the irrebuttable presumption is operationalized, if you'll just bear with me, there are a few steps to it. So the way it works now is that once a report is indicated, OCFS asks the local child protective service, and there are about, forgetting the exact number, I think there are about 58 or 59 throughout the state, for all, not only all their investigative notes, but also all of the relevant family court records. So that's the petition, that's any orders or findings that the family court judge has made, and that's the disposition. None of those documents are in this record with respect to the subject child at issue. And so what happens is that staff at OCFS, legal staff, compares the allegations in the petition and the indicated report, reviews the orders to make sure that no findings of fact were made, and then confirms that the disposition is one of the types of disposition where this irrebuttable presumption can be applied. And so, yes, it would require reopening this and going back and this is not something that the court, in other words, could do purely as a legal matter on this record.
I'm not sure I understand that. A court can take judicial notice of judicial orders. The order is plain on its face.
So
There's not an ambiguity in the order.
I think it would be quite unprecedented for this court to go beyond the record, take judicial notice of family court.
Of a
Proceeding.
judicial order? Of an order? That's what we're talking about, the
Of the
order,
Of
not,
the petition as well, of the pleadings and the order in those proceedings, and then apply a legal presumption. I think that would be quite unprecedented, and it would be retroactive.
well, in any event, let's go with what you've argued here. Isn't that the case whenever you're applying a change in the law to something that's pending down the pike and in an appeal? You may very well have to go back. That might be what the change in the law requires.
It may be, but I think in those cases, the legislature is usually quite explicit that that's what it wants
But that's a
to
different
do.
story, whether or not you think it's retroactive gets you back to Judge Halligan's question. Is this really a case of retroactivity or just application of a change in law to an appeal that's pending at the time?
Well, for the reasons explained, we think it's truly an issue of retroactivity because what the legislature amended was the steps in the administrative review process that take place at OCFS. It did not simply enact a new substantive legal presumption that anyone, OCFS, the appellate division, or this court could apply. And there are many steps associated with doing so. If I could just briefly return to the right to counsel issue and the issue of cost. The calculations that we provided.
Let me just ask you, though, before
Of course.
you will have time, because I think it's a quick answer. I hope it's a quick answer. Just staying on this point, do you agree that if the court happens to find in favor of Ms. Jeter on this question of the application of the statute to her case, that we need not address any of the other issues because assuming, yes, that the order fits within the statute, it's dispositive and it gives her full remedy that she's seeking? Do you agree with that?
Yes, it would give her
Okay.
full relief because it would change the report from indicated to
All right.
unfounded. Yes.
Thank you.
Going back to the issue of cost, just briefly, the figures we provided are for attorney's fees alone. So in order to implement any kind of paid counsel mandate, OCFS would not only need to spend these tens of millions of dollars in attorney fees, but would need to stand up from scratch an entire indigent defense infrastructure parallel to that of the unified court system, because OCFS is an agency, it's not within the court system. It has no inherent supervisory authority over lawyers. Unlike cases where a trial judge can appoint counsel for somebody because they have such inherent supervisory authority and they're authorized to under the CPLR, there's nothing like that for OCFS. The only authority it has is through contract, so it would have to do this through individual contractual assignments. It would need staff to effectuate that. And because of these costs,
I bet you could work something out with the Indigent Legal Services Board, which I chair.
perhaps, but I think that essentially to the extent that offering counsel to individuals in administrative hearings, to the extent there are unanswered questions about how many hearings this would affect, although we've really tried our best, given the information we had at the time, to estimate that. This is really a question for the legislature. as
But
the
if
court
it's a
said.
constitutional right, it's a constitutional right. We don't say, it just costs too much. It just costs too much to comply with the Constitution. We're not going to do that today.
But I
Correct,
thought this
correct,
is a
Judge
due
Rivera, but-
process, right? It's not a
If you made some other constitutional arguments, you may not think they're preserved, but you made some other constitutional arguments.
Right, again, I'd just like to go back to what I said about Gideon and the Sixth Amendment, which is if you're talking about the constitutional procedural due process right, then there is an explicit balancing of the state's interests, including
What other
fiscal interest.
administrative proceedings in New York is there a due process constitutional right to counsel in?
The only one would be parole revocation, and it's highly distinguishable because you're talking about physical liberty, and that is the part of Minichino that I remember. That was part of the court's holding.
And here, there's an argument made by the other side that there is a liberty interest at stake. Do you dispute that characterization of the interest?
No, there is a stigma plus liberty interest, as this court held in matter of Lee TT. But we're saying that when you're weighing the various interests, may I?
Yeah, please continue.
When you're weighing the various interests here, physical liberty interests, things like that, would be given more weight in the Matthews v. Eldridge balancing test than a stigma plus liberty interest like the one identified in Lee TT.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Amy McKenfield on behalf of ACS. Your Honors, I'd like to just briefly address the merits here, which are quite straightforward. Here, this Court should affirm OCFS's determination because it is supported by substantial evidence. And the substantial evidence standard, it's a minimal standard. It simply requires something more than conjecture or speculation. It can be based on inferences that are probable. They don't necessarily need to be the most probable. And here, there was certainly more than enough evidence to meet the substantial evidence standard. We have the child's consistent statements in more than one interview with more than one ACS caseworker describing
What about the recantation letter? What if we thought that was error not to accept the recantation letter?
So a couple of points on that, Your Honor. The recantation letter, as we've argued, the hearing officer had the discretion not to admit it because it was so unhelpful as to be essentially irrelevant or immaterial. But even if it was admitted, it wouldn't have moved the needle for the same reasons. This is a letter that was undated. There was no information provided as to the circumstances under which the child wrote the letter. The letter didn't specifically address the injuries at all. It offered no alternate explanation for the injuries. And while the mother now argues that she had submitted the letter to family court, she didn't raise that claim at the hearing, and she still hasn't provided any evidence to show that this letter was ever submitted to family court. Even if it was submitted to family court, it seemingly didn't persuade the family court, because at the 1028 hearing, when the family court remanded the children to Jeter and Lang, it did so on the condition that the children not be alone with Jeter. And
Some of the points you're making seem to emphasize the importance of having counsel.
Your Honor, we have not taken a position on the right to counsel for the city, but we do agree with New York State that the right to counsel and the retroactivity point are not preserved. And I'd also just like to touch on the retroactivity point. The reason why this would be an inappropriately retroactive application of the statute rather than simply an application of a change in law is because the provision, it specifically says that this presumption would be applied in the hearing. And the hearing process had long concluded by the time that Jeter raised this argument. The legislature set a future date for the effectiveness of the statute when it enacted the statute, and when hearing processes occur after that date, the presumption will apply. Before that date, they don't. It's a clear application of the plain language of the statute. Going back to the substantial evidence, again, Your Honors, we have
What does it mean for the presumption to apply in the hearing if what the presumption gets you is not a result of the hearing, but a result of an action on the register?
As New York State explained, the hearing process starts with an administrative review.
Right.
So once that review concludes that this is an appropriate instance to apply
But doesn't the presumption, isn't what triggers the presumption the conclusion of the hearing?
The conclusion of the family court proceeding.
Right.
Yes.
So the presumption doesn't really apply until that process is over, no?
And then it will apply to any pending OCFS hearings.
And are you saying that you would actually reopen the hearing, or would this not be a more ministerial act? If we were to disagree with you and find that it did apply, with respect to, for example, Ms. Jeter's case, would there be any reason to reopen a hearing and have a new proceeding, or would it be a ministerial act of giving effect to that determination?
I think New York State explained better than I can the process involved, but there is an administrative review that determines whether or not this new provision would apply. And again, the statute is very clear that these provisions apply to the hearing, and again, the hearing process had long concluded. So because the OCFS determination is supported by substantial evidence, and because Jeter's other arguments are unpreserved and otherwise lacking in merit, we ask this court to affirm.
Thank you.
Thank you.
Your Honor, the Bingham Court case and other cases that the counsel referred to were cases where an issue had not been raised in the court of first instance. The right to counsel was raised. Ms. Jeter raised it in her Article 78 petition.
Could you respond to the exchanges we were having about what would actually happen if we were to conclude that this was a change in law and it applied as a operational matter?
And what would happen to Ms. Jeter? She would win her case, her name would be cleared.
No, but I
and
mean,
she'd go home.
I take it the argument that your adversaries are making about why this, in their view, is a retroactive application as opposed to a change in law is because they say the statute says it applies to a hearing, and also I understood from the state that there would have to be some reopening of a hearing. In your view, as a operational matter, as an administrative matter, what would happen to Ms. Jeter and anybody else similarly situated? Is this ministerial? Would you have to have a whole new proceeding? How do you see it playing out?
Because she prevailed in the,
Yes.
in the family court, if there was a new hearing, there would be nothing to hear because the law is very clear. At an administrative hearing, the family court ruling in favor of the parent creates an irrebuttable presumption.
So it would be a
that the name
mechanical
must be
application.
sealed. What?
A mechanical application of that
It would be a
presumption.
mechanical application, that's correct.
And
Are
to
there-
go
Are there
back
any
to
regulations that have been passed in terms of what process they now have to follow?
Not as of the day before yesterday. That's when I last checked. There have been no, there is one administrative directive from 2021, which the state sent to all of its employees, saying that the irrebuttable presumption applies to all parents who prevail, including those who prevail after an adjournment in contemplation of dismissal. So that's Ms. Jeter. Other than that, I'm not aware of any.
Other than
regulations.
that notification,
Other
I'm
than
sorry,
that
other than that
notification.
statement, I'm sorry, in that document, does it then say what they are supposed to do with this change?
Yes, what they are supposed to do with this change is that at an administrative hearing,
Okay.
if somebody introduces into evidence
I see.
that the family court case was dismissed, that's the end of the hearing.
And that's the only way someone is going to be able to present the resolution in family court?
No, because prior to the actual hearing itself,
Yes.
and this is, there is, as state's attorney says, the state conducts an internal administrative review. This is a paper review, has nothing to do with the trial, and they look to determine whether or not the case can be resolved without a trial. First, if the parent had a case in family court and lost, the parent is going to lose the hearing. Now, as of 2022, if the parent had a case in the family court and won, the parent will win the hearing, and at that point, the state will say, there's no need for a hearing because there's nothing to hear, the parent prevails. The court asked about other constitutional rights. This court that trigger a right to counsel. This court held that not only parole revocation, but also forced administration of psychotropic medication triggers a right to counsel at that administrative hearing. Two of the appellate division departments have ruled that in sex offender registration cases, there is a constitutional right to counsel. There's also a statutory right.
You know, I asked that question of your adversary because in some respects, the right that you seem to be defending here, to me, seems like a property right. The ultimate purpose of getting your name off the SCR is to be able, or at least for this petitioner, is to be able to get employment in the child care industry. And I'm still wondering exactly what the liberty interest is. I understand the reputational issue, but the liberty interest sort of escapes me a little bit.
Because this court in Lee T.T. and the United States Supreme Court in a string of cases, mostly in the early 1900s, said that there is a right to work in your chosen profession, and that is a liberty interest, not a property interest. Ms. Jeter is currently employed, but she cannot work in her own profession. Now, for many people, especially for poor minority women, childcare is the only field that is open to them, and so that if they don't get a job in childcare, they are not going to get a job at
So
all.
in
And this court recognized that in
So
Lee
have
T.T.
we, in other cases, said that if your right to work in a specific particular profession, you can cite a case?
Lee T.T. against Dowling, which was really the seminal case dealing with
But
state central
other,
registers.
in more recent
that was
decisions, with
19
respect to, for instance, a lawyer's right to keep their license, are all cases where your ability to work in your chosen profession, every one of them, you're saying you do have more than a property interest? It is a liberty interest.
Well, I am not familiar with the issue coming up since 1996 in the Lee T.T. case. Secondly, this is not merely the right to work in your chosen profession, but as Lee T.T. said, and as study after study cited in our brief has shown, that this affects a person's individual family life as well. Ms. Jeter,
So it's more than a property
it's
interest?
more than a property interest. That's correct.
Thank you, counsel.
Thank you.